And I will get us started. So, hello, everybody. I'm Stephen Goldmeyer. I use he, him pronouns. I am the board president of the Indigent Defense Research Association. I'm very proud to be in this role, along with really great people on our board and, of course, our really great community. For those who are joining us who don't know a lot about IDRA, I thought I'd talk a little bit about who we are and what brings us here today. So IDRA stands for the Indigent Defense Research Association. It's as Janet Moore, one of our founders, likes to say, it rhymes with Hydra to connote an entity that's many-headed and hard to kill. So we are a persistent organization with lots of different types of people across lots of different areas of indigent defense research. We have lawyers, practitioners, people who do this work on the front lines. We have social workers. We have investigators. We also have policymakers, funders, all sorts of folks, and of course, researchers who work in institutions, but also who work in public defender offices to do research. So with that huge diversity of people, we try to bring people together to have conversations that wouldn't be as easy to have in other contexts that really speak to all those different areas of how indigent defense works and how to make it work better. So we're very proud to bring IDRA together once a month for calls, webinars on different topics that are really driven by the members of our community. We draw our calls from people who are part of the community, and we draw our calls from what people are interested in the community. And we are proud to present our March call with Eve Primus. So I'll pass it over to Lisa to do a little bit of an introduction. Lisa's also an IDRA board member. So take it away, Lisa, for the introduction.
Thank you, Stephen, and thanks for providing that background for everybody joining us today. I'm very excited to introduce Eve Primus as our March monthly meeting presenter. If you don't know her work, she is a professor of law at the University of Michigan and the founder and director of MDefenders and the Public Defender Training Institute, and also directs Data for Defenders. And before joining the Michigan Law faculty, Eve worked as a criminal investigator for the Public Defender Service in Washington, D.C., and as a trial and appellate public defender in the Maryland Office of the Public Defender. I told Eve that I would have her introduction be short because you all want to hear from her, not me, but I do hope that you look more deeply at her biography because she has quite an impressive history. And I will pass the mic to Eve.
Well, thank you to Stephen and to Lisa for inviting me to be here today and for that generous introduction. And thank you to all of you for coming to hear a little bit about a new project that I have launched in cooperation with a lot of others to try and improve and encourage defenders to incorporate cutting-edge social science into their criminal defense advocacy. So, I guess what I will do is talk at you for a little bit to explain the project, and then I'm happy later to open it up to questions and comments. So I'll start sort of at the very basic beginning, which is, what is Data for Defenders? Data for Defenders is a project that encourages public defenders around the country to incorporate cutting-edge social science research into their criminal defense advocacy and provides them with sample briefs and motions that show them how to do it. So this is a screenshot of the website itself. I will bring the website up later and I'll show you how to play around on it and how to use it. But that is the general idea behind the database. I don't know about a lot of you. I know when I went to law school, we learned a lot about how to read cases and how to read and research statutes. But we were not taught how to find and incorporate relevant social science into our advocacy. And there has been an immense explosion in social science research on the criminal legal system in the last 20 to 30 years. And a lot of that data is incredibly useful for defenders, but many of them are overworked, underpaid, and have not gotten the technical training about how to find and research these studies, nor do a lot of them have an incredible amount of extra time to read 70, 100-page scientific studies about the ways in which people communicate or what this does psychologically if presented to a jury, or the ways in which race has affected a certain kind of inquiry, or a lot of information about forensics. And so what we're trying to do is take advantage of the fact that the students at Michigan Law are trained to find that kind of social science and help translate that into more tangible things for public defenders and criminal defense lawyers around the country. So how does it work? All right, so works a few different ways. First, public defenders and defense attorneys from around the country can send sample briefs or motions that they have worked on to us, and we can review them for quality, accuracy, and redundancy with what is already in our database. So one of the ways in which we get sample motions and briefs that incorporate social science is through submissions. So this is a screenshot that you can see of our submission page. It explains that the primary submission requirement is that this be an argument that is predicated on social science, that we are not a database that is designed to replicate legal databases that a lot of offices have. Like, hey, you have a Fourth Amendment motion that you want to make to suppress certain evidence. Here's the case law that supports that. Those databases are incredibly important. It's just not the project that we are up to. What we are trying to do is translate social science research into effective defense advocacy. So when we get a submission, we have a student team here that will both shepherdize the citations, read the underlying studies, make sure that everything actually says what the document says it says, and we'll look at the document itself for both quality of argument and writing, and compare it to the documents that we already have in the database to make sure that it is not redundant. One of the things that I know many of you probably who use Defender databases know is that over time they can get unwieldy. Like, people just start dumping more and more documents. You've got 30 different examples of one kind of Fourth Amendment motion. Some of them are 300 years old, and it doesn't wind up being a very useful database. So one of the things we do is try to remove older documents and update them with new documents so as to keep the database current. There is also an option here to redact confidential information. Different offices and different lawyers around the country interpret their ethical obligations differently about this. We obviously, one can get permission from a client to share this information if the document is public. Some people like to redact out information. We will automatically redact sensitive information like dates of birth or any identifying information that we think explains in more detail who a person is within the document. But the idea here is to have the research as applied to the facts available to defenders. So that's one way in which we get documents. Another is the team of MDefenders students that I have here at Michigan Law also scours and looks for already filed briefs that would be a good fit for our project. So to the right is a screenshot of a brief that was filed in 2023 in the Michigan Supreme Court that addresses some of the most cutting edge research on shaken baby syndrome that we put onto the website for individuals to use as one example. That team of students will also draft sample motions and briefs that are based on cutting edge social science. So researchers can send us studies that they think should be included in criminal defense motions, and my team will work that up to write up sample motions and briefs using those studies. So for example, you see a motion that we actually just recently put on the database to amend a jury instruction on a defendant's right not to testify at trial, arguing that most jury instructions that say you cannot use a defendant's silence against them blindfold jurors to the actual reasons why an innocent person might not testify, which winds up leaving jurors to their background assumptions that innocent people testify and guilty people don't take the stand. And so we argue using flight instructions as an example of a situation where some jurisdictions at least have been willing to provide in their jury instructions innocent reasons why a person might flee. We use those as an example to argue that a similar kind of unblindfolding should be done with respect to a motion or a jury instruction with respect to the right not to testify at trial. So that uses research, some of which is older, some of which is more recent, and it's something that the team drafted under the supervision of me and attorneys on my staff. And so that's another way in which we try to get cutting edge social science research out into the world. So what is the criteria for inclusion? As I said, it must incorporate social science to support defense advocacy. It raises sort of a big question that many people might have. What is social science for our purposes? We have a pretty broad and capacious definition of what constitutes social science. In its most general sense, It's the study and manner in which people behave and influence the world around them, including the scientific study of how people act and what causes them to act in the way that they do. It can draw on psychology, political theory, organizational behavior, communication, statistics, linguistics, economics, public health, sociology, politics, and other disciplines. It is just not legal precedent and statutes. So how is it useful to defenders? We have found in many different ways. It helps defenders relate to their clients. If they have communication barriers or intellectual disabilities, social science data can help people explain how to bridge those differences and gaps and have better communications with their clients. It informs how defenders negotiate with prosecutors. There's a ton of social psychological research on negotiation strategies and tactics. It affects how defenders interact with judges and juries, how they process information, what reactions they are likely to have, what they can and can't disregard. It informs how to select jurors. We actually just posted a relatively recent study translating into how to make better Batson challenges based on social science research about racially discriminatory practices that prosecutors engage in through linguistic patterns that they may or may not be aware of. It can help defenders communicate more effectively to fact finders about the evidence that they want to present or the arguments that they want to make. And it can inform substantive legal arguments that defenders make for their clients. If you want to make an argument that no reasonable person in these circumstances would feel free to disregard the police and go about their business such that they are stopped under the Fourth Amendment, there's a lot of research that suggests that an individual's race informs when they might be feel free to disregard the police, particularly in jurisdictions where there's been documented evidence of police racial profiling and using excessive force against minority communities. So that's one example of a way in which social science can inform and buttress what would otherwise be a legal argument that was supported by law, but not by research. So as the database will show, there's a lot of different mechanisms for bringing social science into courtrooms. There's motions in limine, everything from Daubert or Frye motions to exclude junk science to 403 motions that say this is unfairly prejudicial and likely to be taken by the fact finder as unfairly prejudicial in ways that outweigh its probative value. Motions to suppress evidence like the Fourth Amendment claim I just mentioned. Lots of ways in which individuals can have courts take judicial notice of social science research or statistics in order to bring that before the court, or get prosecutors to stipulate to certain social science facts. It informs the ability to ask for and bring expert testimony into the court on behalf of the defense. It also can make for better cross-examinations and arguments to the fact finder. As I mentioned before, it can inform the ways in which jury instructions should be crafted. And there is a ton of social science research that can affect mitigation arguments, not just at sentencing, but also at bond review hearings, plea bargaining, probation revocation, etc. So there is no world that defenders work in that is not touched by social science research and data, and for which social science cannot be a really immensely powerful tool to support their advocacy. So in addition to requiring that the motion or brief include social science data or research to support its position, the other criteria for inclusion, are that the data cited must be accurate and it must be well written. Sometimes we have gotten submissions where we think like it's very confusing or convoluted, and what I will do is have the students just draft up a better written, clearer, simpler, non as fact specific motion that defenders can more easily digest if the submission has 1,000 different defendants and a lot of factual irregularities that sort of put a lot of cognitive load on the reader. It also must be up to date with respect to the research in the field so that it is not outdated, and it can't be duplicative of motions or briefs we already have in the database. Though I will say for certain kinds of things like forensics, sometimes we will put a couple of different examples in that attack the forensic science from different perspectives, but we are very mindful to not overwhelm the database with too much. So As I said, I have teams here that check for each of these things under attorney supervision. So I guess enough sort of chatting in theory about the website. It is called datafordefenders.org. It's pretty straightforward to find. If you open that website, which I'm doing on the shared screen, you can see the database itself is just right there on the website. It's very, very user-friendly. You can see at the top, it's a table that is set up with a title, a description of the content, the date on which the brief or the motion was filed, the jurisdiction to which it applies, and we have categories that we have put the motion into. And then if you want to download that motion, you just click on this download link. So I think there's a lot of ways in which this database can be incredibly useful. I have encouraged defenders actually to just read through the title and content descriptions of the database as they go down. I think it can encourage defenders to think creatively about ways in which social science arguments might be useful to them that they might not have otherwise thought of before. And when they have a relevant case, they'll trigger in their memory, oh, I think there was a way in which that might be challengeable, and go back to the database to look for it. I also think you can search by category. There's a drop-down menu here with all different categories. And if you click, like let's say you had a case that had character evidence in it, and you click on character evidence, you'll see submissions here of documents that address issues related to character evidence, incorporating social science research into those. And you just hit the reset button to bring it back to the full screen. You can also just search for a keyword. Like if you have a shaken baby syndrome case and I type shaken baby, it's going to pull up all of the shaken baby. We have 3 different documents in the database right now that address shaken baby syndrome from different perspectives. So you can just reset and it will go back to the original document. You can search by jurisdiction. You can arrange each of these columns by order. It is defaulted to set up reverse chronologically, but you could tap this to search by jurisdiction and then just reset it to go back. So it is meant to be a very, very user-friendly database. If you look right now, the current categories on this database really run the gamut, from Fourth Amendment issues to studies about age, custodial interrogation, a lot of stuff about evidence, including forensics evidence, eyewitness and non-eyewitness identification procedures, improper arguments by the prosecutor, a lot on jury psychology, jury instructions, and jury selection, things about the police, a lot of studies about race, including things specific to California's Racial Justice Act, sentencing arguments, and a lot about witnesses, everything from experts to lay opinion testimony to testimony about specific subject areas. Importantly, I feel like I need to point out, we launched this database only this past fall, so it's really new. This is going to continue to grow, and as we get more submissions, the categories will grow and the number of documents will grow. So how defenders can use the website itself, I sort of mentioned before. There's the idea of perusing the table and reading the title and the content categories to get sort of creative ideas flowing for motions that you could raise. You can search it by each column, right? Arranging it by jurisdiction or filing date or category. You can search in the jurisdiction and category bars, or you can type a keyword in that will enable you to find any documents that discuss that subject area. So as of right now, the other big thing you'll see if you go to the website and you scroll down to the bottom of the web page beyond where the database is you will see a list of partner offices and organizations that have signed on to work with us. Right now, we already have, as I said, we just launched this. We have already a dozen partners, including the National Association for Public Defense, Gideon's Promise, Partners for Justice, a number of statewide public defender agencies like Colorado, Alaska, Ohio, the California Appellate and Post-Conviction Office, the Indiana Public Defense Council, and then even county-based offices like the Metropolitan Defender in Portland, or the Kentucky or the King County Department of Public Defense in Seattle, or the San Bernardino County office. So lots of different agencies that have partnered with us. What does it mean to be a partner? It's a very low requirement, in part because the goal of this entire database is to provide assistance and support to those doing indigent defense work, not to tax them. As Lisa said at the beginning, I am a public defender turned academic, and one of the things that I think is incumbent on me as a researcher at a public university is to provide resources to the public that help raise both the level of awareness about social science and aid public defenders in what is an incredibly difficult road that they face in an under-resourced and overworked environment. So I am not here to try and tax them. All it means to be a partner is that you are committed to regularly sharing information about the website with your attorneys and staff, that you promote the project on your website, your social media, like we have signs and other promotional materials that you can use, and that you encourage your attorneys and staff to use the website and to contribute documents to it. Some of the benefits of partnership are recognition on the website as a partner, and I send out monthly emails to the partners that highlight new content each month. Sometimes that new content is not as easily findable if you don't know how to look for it, because if we get a submission of a brief that was filed 6 months ago that has really great stuff in it, when I upload it to the database, it is not going to be at the top of the database because there will be more recently filed information. So that's a little bit of an overview. I guess this is the part where I will turn to the chat. I put my contact information up here to say this is, how to reach me with questions or suggestions. And if you're interested in partnering with us, there's the MDefenders information. If you are a defender or a researcher and you have a document that is a motion or a brief that you would like to include in the database, or if you have a research study that you think should be turned into a motion or a brief that would be useful to defenders, you can submit that document to us through the website. There is on the website a button that you can hit to submit a document at the top right of the website. So that's a sort of crash course of introduction into what we're doing at Data for Defenders. I will turn, I guess, to the chat now for some questions if people are interested in adding questions there. And so I'll start, I guess, with the first question was, do I incorporate work supporting class action or other litigation aimed at broad policy change? Yes and no is the answer. The yes part is we do have briefs and motions on the database that come from habeas actions or from civil class actions that are relevant to criminal defense attorneys around the country, but both because they provide arguments for individual criminal defendants and simultaneously for broader change. The no part is I would not post on the website information that has social science that was not relevant to criminal defense attorneys, because the project is designed for and marketed toward criminal defense attorneys. So if it is class action litigation that is aimed at broad policy change with respect to a class of criminal defendants, then that is something that I think would be eligible for the website, and you can see a lot of that already on the website. Is the slideshow or recording linked in the chat for downloading? I have sent it to Lisa, and I think I'll ask Lisa and Stephen if there's a way to make that available more generally. I'm happy to share it in whatever way is most useful. Stephen says it will be posted on the YouTube channel also, so you'll be able to see it there. Okay. Is there a requirement that submitted briefs include the client's name? No. So let me escape out of the slideshow. Now you're looking at my children. Those are my children. Let me bring up the website. There you go. If you look on this is the website. This little button up here in the right is the submit a document button. When you click on this, you're going to be brought to the screen that enables you to submit something to the database. There's a section here that explains the submission requirements, that it must be relying on social science or to advance arguments that defense attorneys can use when representing individuals faced with criminal charges or potential incarceration. And it defines that broad definition of social science. There's also this section about confidentiality, which is we automatically redact highly sensitive information, addresses, phone numbers, social security numbers, though I don't know why that would be in the document. But we will leave other information. If you would like to redact it before you submit it, you are welcome to do that. If you would like to ask us to redact something, you are welcome to do that as well. As long as your redactions don't compromise our ability to see how the social science informs the argument, we are fine with that. So absolutely can take the client's names out if you would like. The only thing I would say is if you do take clients' names out, it is harder if you filed a motion and you won. It is harder for other defenders to find that victory and try to use it to their advantage in their cases. If you want to take out client information and include a link at the end to information about a case where this argument was victorious, you could also do that. And it would just be a citation and they would have to be able to find that case on their own. Let's see. Other questions that people have? I have more than I can say, but I figure I want to make sure to pause here to answer your questions first. Can an individual receive the highlights email without their organization or office being a formal partner? It's an interesting question. I have not been asked that question before. I am a little bit loath to say yes for the following reason. I want to be able to give some incentive to people to partner with us because it is one of the only ways to get information about the database out there. And if I say yes to anyone who says, can I just get the updates without being a partner, there's not much that provides that incentive. I'm happy to think about it and to hear arguments that might suggest that that's a better way to do it. The database itself is open to anyone. This was something that I discussed with a lot of defenders before we launched the project. There are a lot of organizations and agencies, as you know, that have password protected databases. My goal here was to reach defenders around the country who are not only in the most well-established public defender offices who often already have access to a lot of resources and mentorship about how to make good arguments and raise good motions. I also wanted to reach out to defenders, even if they were not in offices where they had a lot of support. As many of you know, about a third to a half of indigent defense representation in this country is not provided even through full-time public defenders. It is provided by individuals who are working as contract attorneys or through assigned counsel systems. And in many respects, part of the structural problems with contract and assigned counsel systems is that they don't get structurally as much training or information and access to databases as institutional public defender offices do. So I want this to be an available resource to those defenders as well, which is why I don't have any form of password protection on the website. So even if you don't get my highlights, you still can go to the website and search for or peruse the tables to find any information for a case that you might be interested in. People have asked me, does this mean that prosecutors or judges can also access this resource? The answer is yes. That also was something that was not done willy-nilly, but that a lot of thought was put into. I think that's okay for a couple of reasons. One, I could not cabin or limit this to only defenders and still have the goal of reaching individual practitioners because there's no way that I would be able to verify who was a defender and who wasn't. I mean, I could have a statement that people have to sign that says, I am a defender, but that's about the best that I could do. And the truth is, like, I actually think it might be good for some judges to learn about some of this social science research, even especially when it is done in the context not of a case that is directly in front of them that might involve gruesome facts or pull at their heartstrings in specific ways. That sometimes judges can be educated about the importance of social science research in ways that can be useful in future cases, and this database can perform that function. I think also in a world where there's a big push toward a movement toward progressive prosecution, I also don't mind trying to educate prosecutors about some of the trouble with a lot of this. I am of the view that most prosecutors are not going to do substantial social science research to fight against an issue until it is presented to them in a case. And so them seeing these kinds of briefs will not inherently compromise the ability of defenders to make these kinds of arguments. And to the extent there is any danger, the benefits of making this database available to more defenders, in my mind, outweighed those potential dangers, which is why we have this database open to everyone right now. Okay, next question was, is there a legal basis for arguments only federal constitutional evidentiary law or state-specific arguments? Yes, so we have in the database examples of these kinds of arguments that are evidentiary, constitutional, state-based, etc. You're right that the rules can differ state to state. So some of the arguments, like if you look in here at, for example, the Racial Justice Act category, you're going to see this is very specific to California, because California has a very specific statute that entitles defendants there to raise certain claims in a different way, and the jurisdiction is listed only as California. So even if it is specific to one jurisdiction, we're happy to create a category. It just has to be applicable in that jurisdiction beyond one individual for it to be relevant to this database. But for a lot of things, what you will see is, for example, I'll give you the motion to amend the jury instructions on the right not to testify, which I brought up earlier. We crafted this sample motion specific to Michigan's jurisdiction, but you'll see here also a national jurisdiction category, because most jurisdictions have a jury instruction on the right not to testify that is similar to Michigan's, which is to say it is just an admonition that says you can't use the right or the fact that the defendant did not testify against them. And so all of the arguments that we are bringing into play there would apply and be useful to other jurisdictions' attempts to modify those instructions in their jurisdiction as well. We draw on flight instructions in this motion from Michigan and from Vermont in an attempt to argue that changing the instruction on the defendant's right to remain silent would not be revolutionary. It would just be an explanation-based instruction that gives some reasons why an innocent defendant might not testify, in the same way that Michigan and Vermont have instructions now that explain reasons why an innocent person might flee from the police. So that's an example just to show you that, yes, that might be an argument specifically geared toward one jurisdiction, but because it has broader implications for others, we also put it in a national category. So a lot of our motions fall in that way. There are a lot of motions in here that are essentially Federal Rule of Evidence 403 motions about the danger of unfair prejudice that flows from a lot of different categories of evidence based on research. Obviously, states each have their own example of rule or their own version of Federal Rule of Evidence 403, but we put the federal version argument up there, and then we'll allow each jurisdiction's lawyers to tailor it to their specific jurisdiction. That leads me to the following cautionary note that I will make about documents in the database more generally. We decided to create a database that had sample motions and briefs rather than including the studies themselves for a couple of reasons. One, a lot of the studies can be challenging to find behind paywalls, and posting them might have infringed on copyright issues or created other problems. But really, two, was more important, which is a lot of these studies, they're very long and they're very technical. And I didn't want to put the onus on defenders to read a study and then come up on their own with the ways in which that study might be useful. The idea of putting the motions or the briefs up is to provide creative arguments as examples for how defenders could translate the social science into support for legal arguments. And so they are provided as examples of that. Am I aware that there might be some defenders who just sort of cut and paste their facts from their cases into our sample motions? Of course, I'm aware of that. That's a danger whenever you give sample motions or briefs. Would I encourage defenders to read the underlying studies and make sure they understand the arguments before they do that? Absolutely. You will look dumb if you file a motion and the judge asks you questions about it and it's clear you actually don't know what you're talking about. You just cut and paste it from something else. So, I do encourage lawyers to do their due diligence. I also think, especially with some of the things in here that are a lot more complicated and technical, like the challenges to junk science forensics comparisons, that you do your clients and potentially the world of indigent defense a disservice if you file a motion like this without consulting an expert, creating a record, etc., because you run the risk that a trial judge will make a determination based on this motion that then will be appealed and result in bad law within a jurisdiction because the proper record wasn't created below. So we really do encourage people. There's lots of amazing forensics organizations that can help defenders who are looking to find experts. There actually are organizations that are helping to cultivate experts in different jurisdictions to address the problems of some junk science that is emerging. And so encouraging people to, make sure that they are using and creating complete records is also really important. So did we design the site ourselves or use in-house tech staff to do it or hire a contractor? It's an excellent question. This is it is a WordPress database. So those of you, I don't know how many people who have technical expertise are on this call. It's actually a relatively simple database. We created the database in WordPress, and then the IT folks at the law school helped to put the database into this nice, attractive looking website that made it so user friendly. So we did not hire an external contractor to do it. So it sounds like I'm not the only one who is doing this too. So the Galt Center is doing something similar, which is great. I think, when one takes on a project like this, there's a couple of priorities, right, that I had for this that hopefully I have been successful with, though, as I said, this is still a relatively new project. So if people on this call have ideas or suggestions, I am also happy to listen to those as well. The idea, I wanted it to be user-friendly. And I really liked the idea of having this content description. If you look on the website, you will see the content descriptions are pretty specific. Like, some of them are detailed where they say things like, on pages 7 to 8 is where you'll find this information. Pages 4 to 7 are where you'll find this. The reason why we do these detailed content descriptions is twofold. One, I really want defenders to just kind of read through the site's content and be able to digest and get those juices flowing about the varying ways in which social science will be relevant. Because I really think it will not only awaken the importance and ability to use social science for so many arguments that you make day to day, it also will start to get you thinking about other arguments that might be better supported by social science, which just improves the quality of the advocacy for indigent defendants around the country. So I wanted to have that. I also wanted to pin cite certain types of arguments so that for an overworked defender who has limited time, I can say, look, if your case involves this issue, look here. This is especially true when you deal with some of the forensic evidence, because those briefs can get super long. And so if what you're interested in is one aspect of shaken baby syndrome or DNA evidence and not 13 other ones, that pinpoint site can really help you find the relevant information quickly. So one thing was making this aesthetically user-friendly and something that people would be able to peruse easily. I think the other big thing that I'm trying to do, and this is the harder part, which is why in part I'm so grateful to Stephen and Lisa for having me at your monthly meeting, is getting the word out, because this database will only be as useful as the number of people who are aware of it and are willing to both consult it and contribute to it. My team here drafts each month a couple of additional documents to put in here. But it means if it's just my team that is contributing to this database, it will grow and it will still be an incredibly useful resource, but it will grow much more slowly than it could if we had a national community. One thing I really hate, as someone who trains aspiring public defenders and who worked as a public defender herself, is that, we are reinventing the wheel in jurisdictions around the country on stuff that, if we had the ability to share it with each other, could save each other an immense amount of time. And so one of the goals of this database is to say, look, if something's junk science in New Jersey, it's junk science in Washington state too. And if someone has already done a ton of this work, yes, you need to familiarize yourself with it if you're going to try to deploy it on behalf of your clients, but you don't have to reinvent the wheel. And so a lot of what is so attractive about the social science research is that it does have broad national implications. And so the goal here is to, over time, have this grow. Although there is a section of this that is forensics, some of the stuff that I'm most excited about with respect to this database goes far beyond forensics. I think people think science is useful in courts when it's science stuff that is being argued. And I actually think that really undervalues how much social science can be useful in criminal defense advocacy. There's no end to the ways in which studies about race and sex and psychology of processing of information can affect defender arguments. And the research on trauma, on prior trauma, on poverty, on recidivism, on like the ways in which society has turned its back on defender clients is really useful for mitigation across the board. So it's not just at a sentencing argument. Like that bond review argument can be informed by a lot of the same criteria. So I think that I wanted this also to be something that would be useful to defenders and create that sort of national community. So it will only be as useful as the number of defense organizations and agencies and individual defenders and social workers and paralegals and investigators who are willing to use it. So I hope that over time we will get the word out and that it will grow both in terms of the number of documents that it has and in terms of the degree to which people will reference it and use it. Do I read or verify everything posted? Yes, it is a ton of work. I do have funding I'm going to be hiring a lawyer on the staff to assist, right, with this project, as well as some of the other things we have going on at Michigan Law. So that will be useful. It's a ton of work, but it also, this is the nerdy, defender in me. I really enjoy reading it, right? I enjoy learning about different ways to bring social science into courtrooms. I think it makes me a better lawyer for the cases that I do pro bono. I think it makes me a better professor to my students who I teach every year about how to incorporate social science. And I actually think, independent of the project's benefits to the outside world, working with aspiring public defenders at Michigan Law to craft these motions makes them better advocates over the course of their 3 years here. And so when they join the ranks of indigent defenders, having been trained and having had experience with drafting these kinds of motions, I also hope that will have a multiplier effect in the ways in which they encourage this kind of practice out in defender agencies around the country as well. Other questions? Thoughts? Great. That's a wonderful question. If you're a non-lawyer, is there something to bear in mind to make your social science work more useful to lawyers? What I would say is the submit a document button on the website up here is useful for that as well. Or you can email the MDefenders info email that I put up earlier. I should probably put the email back up, right? Let's see, is it still there? They're my children again. All right. Maybe I'll stop the share for a minute and say, I'll put my email here in the chat also if people want to reach out to me. If you have a study that comes out and you think this is something, you don't have to be a lawyer if you are a social science researcher to know, hey, this would, really help with mitigation for individuals who are, being sentenced in criminal courts, or this might be something people could use to challenge like either the validity of certain kinds of evidence or like the weight that should be given to that evidence. You can always send it to us, whether it's in article form or in the form of a study, and it can go on the ever increasing list, right, that I have for the students who are drafting sample motions to look at and decide if there's a way that the research could be made into a motion or into a brief that we can then pump out to defenders around the country. So, I started this project and I feel like, dozens of ideas of motions that I wish existed that I did not see regularly out there in practice. And so some of the stuff that we're now posting, like the most recent one I mentioned about changing the jury instructions on a defendant's Fifth Amendment right to testify, those came from lists that I had of things that I think should be out there. At some point, right, I hope I will run out of those and I will be relying on the new studies that are coming out. So if you have, come out with an article or a study that you think could be useful, you send it our way and I will put that into the queue as another thing that the student team can work on to get out there. Any other questions? I will share one thing I am struggling with is though this does not matter to me, it might matter with respect to the success of the project. It'd be great if there was some way that we could know or track that the stuff that's getting used and or winning in court, right? Because it'd be lovely if I could put a little note on the front of a motion that's like, this was argued successfully in this case or in this jurisdiction. I think a lot of judges are more willing to do things that seem unorthodox if they know they're not the first one to go out on a limb to do it. And so having that kind of feedback both would show us what things worked and what kinds of motions people want and need, and also, right, help in getting other courts around the country to give credence to the motions. It's just really challenging, and I know, like, in a world where I'm sending this out and it's going from partner offices and agencies down to line defenders or even to assigned counsel or contract lawyers, that the feedback mechanism is going to be weak at best. So that's one thing it would be lovely to be able down the line to think about incorporating. But I don't yet have the mechanism to do it. Do I have arguments in response to judges who think that science and research is junk? Yeah, so this is one thing, it's a great question. I think, and one thing I say to the defenders I'm training here when I talk about incorporating social science into their defense advocacy is, do not be surprised if the first time you stand up in court and you try to raise these kinds of studies, if the judge looks at you like you are from another planet. In jurisdictions where judges are not used to considering social science, many of these judges came from a time when law schools did not teach this information, as I mentioned earlier. And so they're not scientists. They didn't go to law school to be scientists, and they find it all somewhat foreign. I think that it sometimes takes time for these kinds of arguments to sink in. And so one thing I tell to the students who I train on doing this is, don't give up. Like, the first time you make the argument, it might get rejected. They might look at you funny. But if you continue to raise these kinds of arguments, it will become normalized that those are arguments that get raised, and you might get some traction. I also am very careful when I train my students as to how to raise these arguments, to say there are sort of erudite, elitist, not so great ways to make these kinds of arguments. and there are better ways to make these kinds of arguments. Just citing like all these details of a study without actually explaining what it means and why it matters is not going to be useful to a judge. So one thing I try to do in all of the motions that we draft, and I encourage in the motions that we get submissions on, is not just like, you know, race matters, see this study, which actually does not do anything for the judge unless the judge is going to go read that whole study, which they're not going to do. Instead, what I encourage the students drafting the motions to do is to say, there was a study that was conducted at this university where researchers asked these questions, and this was the reaction of the subject participants, and they led them to this conclusion, and this is why this conclusion matters under this legal test, because it informs the court's argument in this way. So you're kind of almost getting them to think about science without calling it science, without just throwing up what seem like foreign studies, but arguing it in the same way you would argue basic facts about human existence. That's what a lot of the social science is it's studying and analyzing phenomena on the ground and just providing a better argument for people who want to say things like race matters, and not just relying on the judge to just agree with that, but to sort of show them that it has to matter in some way. I mean, are there judges who will not listen to you? Of course, but any public defender knows that's true regardless of what you're doing. And so you just keep trying and you will have success with at least some judges. And you might even change the level of practice in your jurisdiction to think that this kind of information matters, right? And should be a part of the analysis. Any other questions? Well, I will encourage anyone who has follow-up questions, ideas, studies, motions that you've worked on, ideas for motions, etc., to email me or to submit on the website or email the MDefenders info@umich.edu address as well. Thank you all so much for the incredible work that you do supporting indigent defense through advocacy, research, etc. And I just so appreciate the opportunity to share with you information about this resource. So help me spread the word and get other people to use it, because I want there to be better arguments for criminal defendants around the country.
Thanks very much, Eve. I'll just jump in and say thanks everybody for being here. Thanks, Lisa, for doing the bulk of the work putting this together. And again, the recording is going to be posted to our YouTube channel. I will send a link around once that is ready. And again, if you want to join the listserv, you can find more information, as always, at indigentdefenseresearch.org. So please go there to see our website, link to our listserv, and join if you would like to be added to our list to be notified of future calls. Thank you, everybody, for being here. Again, thank you, Eve, and looking forward to the next one.